Welcome to the Deep Dive. You've given us a truly fascinating set of materials to explore this time, all focused on the complexities of representing yourself in court, what's often called going pro se, or acting as a self-represented litigant. Okay, let's unpack this. Our mission in this deep dive is to really understand what it means for you to navigate the legal system without a lawyer. We're going to uncover the real challenges involved, highlight some absolutely crucial things you need to be aware of, and point you toward resources that might offer some support.
That's right. And the main source you shared is, well, it's a pretty comprehensive guide. It's titled Pro Se Litigation, an AI guide for self-represented litigants.
Right.
And it helpfully covers both the federal and Massachusetts court systems, which is, key for understanding the specific rules that might apply depending on your situation.
Yeah, what immediately struck me looking through this guide you sent is just how many people are doing this, representing themselves, I mean.
It seems to be a growing trend, definitely.
And the guide points to cost as a major driver, which, well, it makes sense, doesn't it? Legal fees can be a huge hurdle for so many people.
Absolutely. The guide really underscores this trend, and it immediately raises a vital point for anyone listening. While the right to represent yourself definitely exists, what does it actually mean in practice?
Yeah.
It's so much more than just, walking into a courtroom and telling your side of the story.
Exactly. So let's start with the basics then. What exactly does pro se mean? And are there other terms people might hear?
Sure. Pro se, as the guide explains, is Latin. It means for oneself.
Okay.
It's the legal shorthand for representing yourself in court without an attorney. You might also hear the term self-represented litigant, or SRL.
SRL.
Yeah, that one's becoming more common, probably the preferred term today. And occasionally you might come across pro per.
Pro per?
Yeah, it's short for in propria persona, which also means in one's own person. Basically, they all mean the same thing. You're handling your legal case without a lawyer.
Okay, got it. So where does this right actually come from? Is it just assumed, or is it written down somewhere?
Oh, it's definitely written into law. Though the specifics, they vary a bit between federal and state systems like Massachusetts, and also between civil and criminal cases. That's important to grasp.
Right.
In the federal courts, for civil cases, which is probably what most listeners are thinking about, the right is statutory. That means it comes directly from a law passed by Congress.
A specific law.
Yep, 28 U.S.C. Section 1654. It says that parties may plead and conduct their own cases personally or by counsel. And what's fascinating is this right has been around since 1789.
Wow, since the very beginning, really.
Pretty much. Think of it as your foundational permission slip in federal civil court.
That's a long history. Yeah. So how does that compare to criminal cases? People hear about the right to a lawyer there.
Right, and that's a key distinction. The Sixth Amendment guarantees the right to a lawyer in criminal cases. And there's a Supreme Court case, Feretta v. California, which established that criminal defendants also have a constitutional right to refuse a lawyer and represent themselves.
Ah, constitutional versus statutory.
Exactly.
Yeah.
But that's criminal. In federal civil cases, generally speaking, there's no constitutional right to have a lawyer appointed if you can't afford one. The right you have is the statutory one, the right to represent yourself if you choose to.
That difference seems really significant to keep in mind. What about Massachusetts? Is it statutory there too?
In Massachusetts, it's actually, well, even more deeply rooted. It's part of the state constitution's Declaration of Rights.
In the Constitution itself?
Yeah, Article 12. It says that every subject shall have a right to be fully heard in his defense by himself or his counsel at his election. So it's a constitutional right there explicitly giving individuals the choice. And on top of that, there's a state law, MGL Chapter 221, Section 48, that reinforces it. Plus, the guide mentions other foundational principles in the MA Constitution, like Article XY guaranteeing a legal remedy and Article X protecting life, liberty, property. They all sort of support this fundamental right to access the courts, either yourself or with a lawyer.
Okay, so the right exists, clear enough. But it's not like an absolute free-for-all, is it? The guide mentions limitations. When can't you represent yourself?
That's a really important point. The right is personal. It's about representing yourself.
Right.
And the guide outlines several situations where it just doesn't apply, like corporations and partnerships, because they're seen as separate legal entities.
Okay.
They generally must have a licensed attorney. A non-lawyer officer or partner can't just show up in court for the company. That's crucial if your situation involves a business.
That makes sense. A company isn't the same as an individual person. What else?
Well, you also can't represent a whole group of people in a class action lawsuit if you're pro se.
Right, those are complex.
Exactly. They have specific rules to protect everyone in the class, and courts require licensed lawyers for that. Similarly, you generally can't represent other individuals, like your minor children.
Oh, really? Even your own kids?
Generally, no. There's a very narrow exception in federal court for appealing the denial of a child's Social Security benefits, but that's, like, super specific.
Interesting. Any other limits?
Yeah, a few more. If you're the executor or administrator of someone's estate, you might handle routine probate stuff yourself. But if the estate gets sued or needs to sue someone,
Litigation.
right, litigation, then courts often require a lawyer. Also, and this is important, the court can deny your right to represent yourself if they believe you lack the mental competence to understand what's going on.
Okay, competency.
And the standard for that might actually be higher than what's needed to stand trial in a criminal case. And finally, if your conduct in court is just way out of line, really disruptive, or you refuse to follow basic rules, you can lose the right.
Forfeit the right.
Yeah. The main idea is it's personal. It's for you, not for representing others or legal entities.
Okay, that lays the groundwork for the right itself. Now, the guide really stresses how much preparation is needed if you choose this path. It's not a casual decision at all.
Absolutely not. The guide emphasizes that inadequate preparation is, well, probably the biggest reason why pro se litigants run into trouble. It's not enough to just feel like you have a strong case. You need to be prepared on many different levels.
So let's break those down. The first area the guide hits hard is legal research. What does that actually involve for someone doing this alone?
It's absolutely fundamental. You have to understand the substantive law, the actual legal rules and principles that apply to your specific situation. Could be federal law, state law, maybe both.
Yeah, I didn't know the law isn't an excuse, right?
Not even close. You need to dig into statutes, regulations, and critically case law.
Case law meaning previous court decisions.
Exactly. Decisions judges have made in similar cases that set precedents for how the law is applied. You need to find those and understand them.
That sounds like, well, like being a law student, basically.
Yeah.
Where do you even start?
There are resources, but yeah, it takes effort. Public law libraries, often in courthouses, are a good start. The guide mentions law librarians can guide you to resources. They can't give legal advice, though.
But they can point you in the right direction.
Precisely. Many Massachusetts trial court law libraries even offer help online, like chat or text. Court websites are invaluable too, rules, forms, and government sites like Gov.info for federal stuff. Then there are free online platforms. Cornell's, LII, Google Scholar, Justia, Court Listener.
Lots of online options then.
Yes, but you need to learn how to use them effectively. For federal court filing specifically, there's Pacer, though accessing documents usually involves fees.
Okay. And is there a suggested approach to this research? Feels like drinking from a fire hose.
The guide suggests starting broad. Maybe look at legal encyclopedias or some good self-help guides first, just to get the basic concept.
You get the lay of the land.
Right. Then narrow down to the actual statutes and regulations for your issue. The final and often hardest step is digging into that case law. How have courts interpreted the law in situations like yours?
And you mentioned a critical point there,
Yeah.
making sure the case law is still good law.
Extremely important. You have to verify that the cases you're relying on haven't been overturned or modified by later decisions or made irrelevant by a new statute. That verification step is crucial.
Okay, legal research, huge piece. What's the next critical area of prep?
Mastering court rules and procedures. The guide is crystal clear on this. If you represent yourself, you are held to the exact same procedural standards as licensed attorneys.
No exceptions.
Generally, no. And this is arguably one of the biggest challenges.
Why is it so tough? Is it more than just filling out forms?
Oh, way more. You need to know the specific rules for the court you're in. Federal court. That means the federal rules of civil procedure, plus any local rules for that specific district, like the District of Massachusetts.
And state court.
Massachusetts rules of civil procedure, plus potential specific rules for the court department, like superior court rules. And you absolutely need to understand the Massachusetts Guide to Evidence.
Rules of evidence. That sounds technical.
It absolutely is, especially without legal training. It governs what evidence is even allowed in court, how you properly introduce documents, how to make objections, things like relevance, hearsay. It's complex.
Okay, so evidence rules. What else? Procedural.
Filing procedures, where, when, how, the forms, the fees, electronic filing systems like federal ECF or Massachusetts CFLMA, courtroom conduct, how to behave, how to address the judge, the order of things, and maybe most critically, deadlines.
Deadlines sound scary.
They are. Statutes of limitations for starting a case, deadlines for responding to the other side, discovery deadlines, court-ordered dates. Missing deadlines can absolutely kill your case, flat out.
So it's not just knowing the law, it's knowing the game, the rules of the court. Where do you learn these rules?
Court rules are usually online on the court's website. The clerk's office can give procedural help, but remember, very limited. No legal advice.
Right, just the how, not the what.
Exactly. Court self-help centers were available, and pro se handbooks published by courts or bar associations can also be really valuable for understanding procedures.
All right, research rules. What's next on the prep list?
Gathering, organizing, and managing evidence. Because civil cases are decided based on the evidence presented.
Makes sense.
You need to figure out what evidence is relevant. Documents, witness testimony, both regular folks who saw something and experts. Maybe photos, videos, physical objects.
So identify it, then what?
Then gather it all
Yeah.
and organize it logically, maybe by date or by the issue it relates to or by witness, and keep it secure. Sometimes you might even need to Bates label documents. That's a specific numbering system.
But just because you have something doesn't mean you can automatically show it to the judge, right? You mentioned evidence rules.
Exactly. This loops back to those rules of evidence. Not everything you find is admissible. You need to understand concepts like relevance. Does this actually help prove or disprove a key fact? Authenticity. How do you prove a document is real?
And hearsay, you mentioned that too.
Yeah, the hearsay rule is a big one. It generally stops you from using out-of-court statements to prove something. There are tons of exceptions, but it's a common hurdle. Understanding these rules is vital to know what evidence you can actually use. You have to lay a foundation for evidence.
Laying a foundation, like explain where it came from.
Sort of, yeah. You have to show the judge why it's reliable and admissible according to the rules before they'll consider it.
This is sounding incredibly involved. What else is essential for preparation?
Developing a clear legal strategy. It's not enough to just list facts.
You need a plan.
Exactly. You need to connect those facts to the specific legal claims or defenses you're making. Figure out the legal elements you need to prove or disprove if you're defending. Outline the factual arguments for each element.
And anticipate the other side.
Definitely. Think about what they'll argue and how you'll counter it. Plan how you'll present your case witness order, key documents, and be ready to adapt if things change.
Okay, strategy makes sense. And then there's actually writing all the legal documents.
Yes, drafting necessary legal documents.
Yeah.
These are the formal papers that move the case along. Starting the case, that's the complaint or petition. It lays out who's involved, why you're in court, the facts, the legal claims, what you want the court to do.
And if you're being sued.
You file an answer, respond to their allegations, raise your defenses. Throughout the case, you'll likely file motions requests for court orders. During discovery, you'll draft and respond to things like interrogatories.
Written questions.
Right. And requests for production of documents, requests for admission.
And these aren't just like writing a letter, I assume.
Absolutely not. They have to follow strict court rules on format, the caption, page numbering, font size, everything. They need specific content. You have to sign them, sometimes under oath, and you have to properly serve them on the other side.
Serve them, meaning deliver them officially.
Yes, following very specific rules. And then prove to the court you do it with a certificate of service. There are often official forms, but they almost always need tailoring to your specific facts. Court staff can give you blank forms, but can't tell you what to put in them.
The guide talks about the gatekeeping function of these procedures. What does that mean?
It means these rules formatting, content, filing methods, deadlines, service, they're how the court manages its caseload and tries to keep things fair. If you don't follow them precisely,
What happens?
your papers might get rejected, the judge might ignore them, you could face penalties, fines, or worse, your case could be dismissed, or a default judgment entered against you, meaning you lose automatically.
Ouch. So these technicalities are really serious roadblocks.
They often are, yes, especially for people without legal training who aren't used to navigating this very specific system.
This paints a very clear picture. Representing yourself is a massive undertaking. So the guide then moves to the unvarnished truth, the big challenges and risks you need to brace for. Let's get into those. First up, navigating procedural complexities and rules of evidence. We've touched on this, but the guide calls it the biggest hurdle.
It really is. It's where most SRL struggle. Like we said, the system isn't built for non-lawyers. The jargon, the detailed rules, It feels like a foreign language.
Specific examples.
Oh, constantly. Knowing exactly where to file something, understanding discovery rules, what you can ask for, what you have to give, properly making and responding to objections during a hearing, understanding all the hearsay exceptions. It goes on and on.
And the consequences of errors here are severe.
Absolutely. Evidence excluded, motions denied just because of a mistake, sanctions, dismissal, default judgment. And if you don't object correctly at the right time, you might lose your chance to appeal that issue later. You waive it.
Wow. Okay. Next challenge. Lack of legal expertise and objective perspective. Seems fundamental.
It is. Lawyers spend years learning how to spot legal theories, interpret statutes and case law, build arguments. SRLs might miss claims or defenses, misunderstand the law, or just argue ineffectively.
And the objectivity piece.
It's incredibly hard to be objective about your own case. You're emotionally invested, angry, scared, frustrated.
Right.
An attorney provides that distance. They can analyze risks more clearly, see weaknesses you might ignore, and often negotiate settlements more effectively because they aren't caught up in the emotion of it.
That makes perfect sense. It's tough to see clearly when it's your stuff on the line. What's another major challenge?
The emotional toll and the sheer time commitment. Litigation is stressful for anyone. Doing it pro se multiplies the stress.
Especially dealing with the other side's lawyer.
That can be really tough. They have an ethical duty to be zealous for their client, which can feel intimidating or frustrating. And the workload. Research, drafting, hearings, evidence management, deadlines. It's often more than a full-time job, squeezing into your actual life.
The guide also mentions a statistical disadvantage, which maybe isn't surprising, but still important.
Yeah, research generally shows SRLs don't fare as well, outcome-wise, as represented parties. Now, the reasons are complex. Maybe people with weaker cases go pro se more often.
Right. Could be selection bias.
Could be. But lack of expertise and procedural errors definitely play a big role. And mistakes cost money, too. You might get hit with the other side's costs, waste filing fees, have to redo work, or fail to prove all your damages properly.
The guide then lists some common mistakes. Kind of what not to do list if you go this route.
Exactly. Pitfalls to avoid. Procedural errors are huge: bad service, missed deadlines, wrong format, forgetting signatures, messing up motion filings.
Evidence mistakes.
Big time. Trying to use inadmissible evidence, failing to lay the foundation, making the wrong objections, or missing objections entirely.
What about strategy?
Often people focus too much on emotional appeals or just telling a narrative instead of hitting the specific legal points they need to prove, or they just react instead of having a proactive plan.
And in the courtroom itself.
Things like trying to just tell a story instead of presenting evidence through questions and exhibits, arguing with the judge or witnesses, using improper questioning techniques, forgetting to make sure there's a record being made for appeal,
Dealing with the opposing lawyer.
getting intimidated, asking them for advice which they ethically can't give, reacting emotionally instead of focusing on the legal issues.
And mindset issues.
Yeah, lack of confidence leading to inaction. Or overconfidence leading to recklessness. A big one is just not knowing what you don't know. And signing things without fully understanding them is a massive risk. The guide really drives home this fundamental imbalance. The system is complex, designed for lawyers, but SRLs are held to the same standard. It leads to errors with serious consequences. And remember, no general right to appointed counsel in most civil cases.
It's a tough spot.
And errors made early on in the initial pleadings, service, first motions, discovery can be especially fatal. They can get your case thrown out before you even argue the merits. Plus, the stress just makes mistakes more likely.
It really sounds like trying to navigate a minefield blindfolded. Thankfully, the guide shifts to resources. Where can someone find help? Let's start with federal courts.
Okay, federal resources. The clerk's office is a good starting point. Some courts have specific pro se intake units. They give procedural info, forms, filing requirements. But, and this is critical, no legal advice.
Legally barred from it.
Yes, 28 U.S.C. Section 955 prohibits court staff from giving legal advice. They explain the process, not what you should do. Court websites are huge, local rules, forms, guides, often specific pro se sections.
Handbooks too.
Yeah, many federal courts publish pro se handbooks, overviews, legal terms, pitfalls, resources. Some courts have pro se clinics offering limited free consultations or form help, but availability varies a lot. And public law libraries in federal courthouses offer research access.
What about accessing documents? You mentioned PACER.
Right. ECF electronic case filing access for SRLs varies. Some courts allow it with permission, others require paper. Pacer lets you view dockets and documents online, usually for a fee, though waivers might be possible if you qualify financially. And ADR, alternative dispute resolution, like mediation, might be an option too.
Okay, that's federal. What about Massachusetts state courts? What help is there?
Massachusetts has a really helpful network of court service centers, CSCs, in courthouses.
CSEs.
Yeah. They offer free help finding forms, filling them out, understanding basic procedures, court operations, referrals. But again, no legal advice. They focus mainly on certain case types like family, housing, small claims. You can find locations and info on the trial court website.
What about online help in MA?
Very strong. Mass.gov Yourself has process overviews, forms, finding help info. MassLegalHelp.org is excellent too. Legal rights info, self-help materials in plain language.
And libraries.
Yes, the trial court law libraries are fantastic. Free access to databases, print materials, internet, and importantly, help from law librarians for research guidance finding relevant statutes, cases. Not advice, but guidance. Many offer help by phone, chat, text too. Access to private law school libraries is usually limited, though. Available online at mass.gov and at clerks' offices, some multilingual. But remember, they're blank templates. You need to know how to complete them correctly for your case. The SJC also has guidelines for judges on managing cases with SRLs encouraging reasonable accommodations. And MA uses ePhilema for electronic filing.
Now, what if someone truly can't afford a lawyer in Massachusetts? Are there free or low-cost options?
Yes, there are. Legal aid organizations and pro bono programs offer free civil legal services for low-income folks who meet eligibility rules.
Like who?
Major ones include Community Legal Aid, GBLS, Metro West, Northeast, South Coastal. They can't take every case, unfortunately, but often provide advice, help with specific tasks, referrals, online resources. MassSLRF.org helps you find programs.
Any other options besides full free representation?
Definitely. Limited assistance representation, or LAR.
LAR.
Yeah, it's like unbundled services. An attorney helps with specific parts, drafting a motion, coaching for a hearing, a single court appearance rather than the whole case. It's more affordable, targeted help. The MA court website has info and lists of LAR attorneys. They're still bound by all ethical rules, of course.
And lawyer referral services.
Yes, run by bar associations. They connect you to private attorneys. Some have reduced fee or modest means programs, too.
The guide also mentions the online research tools. Again, free versus paid.
Right. We hit the free ones: Google Scholar, Cornell, LII, Justia, Court Listener, good for statutes, published decisions. Then the paid ones: Westlaw, LexisNexis, Bloomberg Law, Powerful, but usually too pricey for individuals. Fastcase is sometimes free via bar associations.
But access isn't everything, right?
Exactly. The guide stresses this. Just having access to info doesn't mean you understand it or can apply it correctly. Legal research is a learned skill. That's why law librarians and LAR can be so valuable helping you navigate and apply the information.
The guide includes Andy table of MA resources too, which is great. Okay, shifting gears slightly. The impact of AI. This feels very current and potentially trained.
It absolutely presents a double-edged sword. AI, especially generative AI, might offer some help, but it comes with really significant limitations and dangers you have to understand.
How might it potentially help someone going pro se?
Well, it could possibly speed up legal research by processing and summarizing lots of text quickly. Some tools even interface with legal databases. Might help review lengthy documents received from the other side.
Drafting?
Maybe drafting initial versions of basic documents, letters, maybe sections of filings, and potentially explaining complex legal terms or procedures in simpler language.
Sounds helpful on the surface. But the guide immediately pivots to critical limitations, saying AI cannot replace a lawyer. Why is that distinction so vital?
Because AI, right now, cannot give actual legal advice. It's an information processor, not a licensed attorney. Legal advice involves analyzing your specific facts under the law and recommending a course of action. Relying on AI for that is risky, potentially even the unauthorized practice of law, and could lead you down the wrong path.
And it lacks human judgment.
Completely. It lacks judgment, experience, nuance. It runs on algorithms, not human understanding, ethics, or real-world savvy. It can't assess witness credibility, understand subtleties, weigh non-legal factors, or develop truly creative strategies. Chief Justice Roberts recently highlighted this human element that AI misses.
What about confidentiality?
Big issue. Using AI doesn't create an attorney-client relationship. No privilege, no duties of loyalty or confidentiality. Data security depends entirely on the vendor's policies. Putting sensitive case info into a generic AI tool is a risk.
So, There's some serious dangers here if you rely too heavily on AI. The guide outlines several.
Yes, and they're significant. Inaccuracy and hallucinations, AI making up plausible but wrong info, like fake case citations or incorrect legal summaries. Studies show alarming error rates in some legal AI tools. Submitting bad info to court, that can lead to sanctions.
What else?
Outdated information, its training data has a cutoff date, so it might miss recent legal changes. Bias, it can reflect and amplify biases in its training data. Confidentiality risks, as we said, over-reliance hindering your own understanding, a sort of de-skilling, and cost sophisticated AI isn't free, potentially widening the justice gap.
Given all these risks, the guide hammers home the need for human verification. That seems critical.
Absolutely paramount. Any AI-generated legal output must be meticulously reviewed and validated by a human user before you use it or file it. You are 100% responsible for the accuracy of everything you submit.
And courts are noticing this.
Yes, increasingly. Courts are issuing orders requiring disclosure of Gen AI use and certification of human review. Failure can lead to sanctions. And think about it. The need for rigorous verification eats up the time AI supposedly saves, especially since verification requires legal research skills you might lack. Inadequate checking just increases the risk of errors.
Okay, let's talk ethics. The guide breaks down responsibilities for judges, the pro se litigant, and opposing counsel. What's the court's role?
The judge's primary duty is fairness and impartiality to everyone. Can't favor or penalize someone just for being pro se, but they also have to ensure a meaningful opportunity to be heard, protect due process.
So can they help the pro se person at all?
Yes, through reasonable accommodations. The MA Judicial Code mentions things like reading pro se filings more generously, giving brief, neutral info on procedures or hearing sequence, maybe explaining basic evidence rules like authentication, asking neutral clarifying questions, sometimes modifying the order of presentation for clarity, explaining complex stuff in plain language, explaining rulings, referring to resources.
But there's a line they can't cross.
Absolutely. Accommodations cannot become giving legal advice or acting as the person's advocate. It's about understanding the process, not tilting the outcome. A very fine line.
What about the pro se litigants' responsibilities?
They still have duties. They must learn and follow the rules, laws, procedures, evidence. Accommodations don't excuse non-compliance. They have to prepare diligently, research, evidence, documents, hearings.
Conduct.
Respectful conduct is expected. Decorum in court, respectful interaction. Disruptions can lead to sanctions or losing the right to self-represent. Honesty and candor to the court are crucial. No false statements, no fabricated evidence, including from AI, and basic stuff like keeping contact info updated.
And the lawyer on the other side, what are their ethical duties when facing a pro se opponent?
Key duty. No legal advice to the unrepresented person except telling them to get their own lawyer. They must avoid implying neutrality their duty is to their client.
But they still have to be professional.
Yes. Treat the pro se person respectfully. Avoid unfair advantage or excessive hardball tactics. Maintain professionalism. And if the pro se person later gets a lawyer, opposing counsel must communicate only through that lawyer.
It sounds like a real tension point in the adversarial system.
It is. Judges balance impartiality with ensuring a fair hearing. Opposing counsel balances zealous representation with ethical conduct towards an unrepresented party. It's tricky.
The guide then gives a roadmap of a typical civil case life cycle. Good reminder, this isn't usually quick.
Definitely not. Understanding the stages helps you know what to expect. It usually starts with initiating the case. Plaintiff files a complaint or petition, pays a fee, or seeks waiver, maybe fills out cover sheets.
And service.
Right. Formal notification to the defendant, complaint, and summons delivered according to strict rules. Proper service is crucial.
Then the defendant responds.
Yes, within a set time. Files an answer, admit and deny allegations, raise defenses, maybe counterclaims. Or files a motion to dismiss, arguing the case has legal flaws, jurisdiction, venue, failure to state a claim, etc. Failure to respond can lead to default judgment.
If it goes past that, then discovery.
Right. The formal process to get info evidence from the other side, governed by rules, aims to understand the case, prevent surprises, encourage settlement,
That fits.
interrogatories, written questions, requests for production of documents, depositions, oral exams under oath, requests for admission, admit and deny fax documents, sometimes independent medical exams.
And you have to respond.
Yes, truthfully and completely within deadlines. Sanctions for failure. You can object to improper requests, though.
Then motion practice.
Throughout the case, parties file motions asking the court for orders. Big one is motion for summary judgment, arguing there are no real factual disputes and the law dictates they should win. Others involve discovery disputes, amending filings, motions in limine to exclude evidence before trial.
Rules for motions, too.
Oh, yeah. Specific procedures, like MA Superior Court Rule 99C, requiring trying to resolve the issue before filing.
Retrial stuff.
Often a case management conference, early on scheduling, discovery plan, issues, settlement talk. Then closer to trial, a pre-trial conference, finalize issues, witnesses, exhibits, rule on motions in limine, final settlement push, maybe requires a pre-trial memo.
And if no settlement, then trial.
Right. Bench trial, judge decides, or jury trial, key stages. Jury selection, if needed, opening statements, plaintiff presents case, witnesses, exhibits, cross-exam. Defendant presents case, witnesses, exhibits, cross-exam. Closing arguments, jury instructions, a jury. Deliberation, verdict, jury, or judgment, judge. Strict evidence rules apply.
After trial.
Court issues formal judgment. Losing party might appeal to a higher court, usually limited to legal errors, not retrying facts. Strict deadlines and rules for appeals. And note, generally no constitutional right to self-representation on appeal.
So each stage has its own maze of rules.
Exactly. Structured, sequential, intricate rules that favor those with legal knowledge. Each stage has requirements, deadlines, pitfalls. Errors anywhere can be fatal.
Now, the user who sent this material specifically asked about a system or a form for organization. The guide says a universal one isn't really practical.
That's right. Cases vary at too much different issues, different courts, different rules. A one-size-fits-all system just wouldn't work well. The key, the guide stresses, is developing a personalized organizational approach. Being meticulous is crucial.
Why is organization so important for a pro se litigant?
It helps prevent errors, keeps documents accessible, aids preparation, manages stress. Good records and structure are vital.
So what are key components of a good personal system?
The guide suggests several must-haves. First, a comprehensive case file, physical or digital, holding every document. Pleadings, motions, orders, discovery, correspondence. Organized logically, maybe chronologically within categories.
What else?
A case timeline, chronological list of all key events. Filings, service, hearings, deadlines, communications, rulings. Gives an overview, helps anticipate. An evidence log, track all potential evidence. Description, source, date, location, relevance, admissibility notes. Crucial for motions and trial prep.
Keep going.
A contact list, names, addresses, phone mail for clerk, judges' chambers, procedural questions only, opposing party counsel, witnesses, etc., legal research notes organized by issue claim, summaries, citations, how it applies to your facts, track sources dates, argument outlines for motions, trial, opening, witnesses, closing, state the legal standard, connect your facts, reference evidence,
And deadlines.
Critically, a deadline tracker calendar. Meticulously track all deadlines from rules, statutes, court orders, use multiple reminders, ask for extensions before the deadline hits if needed.
It's a lot of work just to stay organized, but it sounds essential.
It absolutely is. Disciplined organization is a strategic tool for SRLs. Helps manage information overload, stay on track, prepare effectively, reduce errors. It's a coping mechanism and a performance enhancer.
This has been incredibly illuminating. A real deep dive into the realities of going pro se. To wrap up, what are the absolute core takeaways you'd want our listener to remember?
I think the main message is, represent yourself is a right, yes, but it is exceptionally challenging. It demands immense preparation in areas most people know nothing about law, complex procedures, evidence rules.
And the risks are high.
Very high. The system is complex, you're held to the same standard as lawyers, and mistakes can cost you your case. Resources exist, but they provide procedural help, not legal advice. AI might offer some assistance, but it's risky and needs careful human verification.
Ethics, the long process, organization.
Right. Ethical duties apply to everyone involved. The litigation life cycle is intricate with traps at every stage. And meticulous personal organization isn't optional, it's essential for survival.
And the guide's ultimate recommendation
Is very clear. If at all possible, get a qualified attorney. Explore every avenue legal aid pro bono LAR before deciding to go it alone. Pro se should really be seen as a last resort, undertaken only with a full, eyes-wide-open understanding of the huge commitment and the very real risks.
That's powerful advice. And it leads us perfectly to our final thought for you, our listener. Given these immense complexities and the potential for devastating errors when individuals must navigate this system alone, what does this truly mean for access to justice? Are there broader systemic changes needed to better support people who find themselves forced to represent themselves in court? something significant to ponder. Thank you for joining us for this deep dive.
This is DigitView.